Guys, today you're taking the bar exam. Here we go. A store owner borrowed $20,000 from a bank to purchase a new delivery truck. The owner did not have much collateral to serve as security, but offered a painting that had been in her family for years. The bank agreed to hold the painting in its safe until the store owner repaid the loan. The store owner signed a written loan agreement that granted the bank a security interest in, quote, all of the owner's personal property. Does the bank have an enforceable security interest in the painting? A, yes, because all the owner's personal property is a reasonable description of the collateral. B, yes, because the bank possesses the painting. C, no, because the loan agreement's super generic language is not a reasonable description of the collateral. And D, no, because the bank did not sign the loan agreement. Pause the video. And here's the answer. With 69% of students answering B is correct. Yes, because the bank possesses the painting. To be enforceable against specific collateral, a security interest must attach to that collateral. If and only if the requirements for attachment are met, then the secured creditor has an interest. Now, this one's a little tricky. There are 3 requirements for a security interest to attach. We'll run through them quickly. 1, the secured creditor must provide value to the debtor. 2, the debtor must have rights in the collateral, or at the very least, power to transfer rights in the collateral. And 3, the debtor must authenticate a written agreement that grants the secured creditor rights in specific collateral and reasonably describes the collateral, which may be a problem here. However, a reasonable description means that the security agreement describes the collateral with sufficient particularity. A so-called super generic description is not sufficiently particular usually. For instance, descriptions like all the debtor's personal property or all the debtor's assets are not particular enough in most cases. However, if the collateral is not a certificated security and is in the secured creditor's possession, which it is here, then the security agreement need not describe the collateral. Now, here's where we'll apply the analysis. Here, the debtor is the store owner, the bank, the secured creditor, providing value by lending the store owner $20,000. Check. The store owner has the rights in the painting because she owns it. Check. The loan agreement, however, does not reasonably describe any collateral, but that's not a factor here because the bank actually possesses the painting. The key takeaway is if the collateral is not a certificated security and is in the secured creditor's possession, then the security agreement need not describe the collateral. Thanks so much, guys. Leave your thoughts, comments in the description. These videos are tough to get out there, so send this to another law student or curious person who may be interested.